Thank you, Mr. Chairman, and I will do that. I just wanted to respond first to a number of the comments that have been made about, again, needing the FBI investigation and what the dynamic of what this committee has done is. It's been said that this committee has changed its procedure. This is the first time that it's conducted its business in this way. Again, as I said yesterday, I think that needs to be clarified and corrected. The fact is that when the FBI does its background investigation, it does just that, a background investigation. It talks to people who may have information about the nominee and takes a statement from them, and then delivers its package of investigative information to the White House, which passes it on to the committee, which is the report that this committee receives from the FBI. It's been said that President Bush reopened the FBI investigation when the Anita Hill information came out. My understanding is, and if I'm wrong on this, Mr. Chairman, please correct me, but my understanding is that when you, as the chairman, finally found out about the information, that information also went to the FBI. Perhaps it was the ranking member who gave the information, the letter to the FBI, but the FBI was given the information. Is that correct?
That is correct, and they said to the White House, in the usual way they do, that they considered it closed.
So the 2 points there. First of all, the full letter, unredacted, was given to the FBI, and the FBI did what it does, and I don't know exactly what they did in the Anita Hill case, but did exactly what it usually does, which is to reopen it, if you will, evaluate the letter, and then again, I understand that the FBI then closed it and sent the information to the White House as they did with the previous report before this allegation came up. Is that correct, Mr. Chairman?
The only thing I can verify is that the FBI did what they would usually do, and that they then, and I don't know what that was, and they probably would keep their own internal stuff to themselves, but they sent a cover letter to the White House saying the issue was closed.
So the FBI did look at this. The FBI did whatever it does in its background check activities, and then resent an updated amount of information to the White House, which the White House then forwarded to us. And then the process which has traditionally been followed in this committee was followed again. And I believe that immediately the chairman opened up an investigation by this committee. That also is customary practice. And as has been stated yesterday, but I will restate again, our committee investigative staff, which is extensive and well-trained, has legal authorities similar to the types that FBI agents do, such that when they conduct their investigations, the people who are interviewed and those who are reached out to by the committee are under penalty of a felony that could result in 5 years imprisonment if they don't respond honestly and correctly to the questions. Every one of the witnesses that was identified has been reached out to. Now, some comments have been, well, they didn't actually submit themselves to a deposition or to some kind of a court process or something like that. As has already been very well explained by some of our other colleagues, when a witness refuses to testify, the alternative is to try to get a statement from them, which the FBI does or the committee does. And in this case, statements under penalty of felony were obtained from all of the witnesses. So I think the argument here that there was some process followed that was not fair is simply inaccurate. The argument that the process followed was not the same as the committee has followed in the past is also inaccurate, and I think that's very critical. Now, to turn to the issue at hand, yesterday we received hours and hours of testimony from two witnesses, and both of them, frankly, made very strong cases. This committee is under the need to evaluate the testimony that was given and determine how it will judge or rule on on the obligation this committee has to give advice and consent. In that context, I came away believing that there had in fact been a sexual assault in Dr. Ford's past. As has been stated, it was not entirely clear when, where, and all of the circumstances, but there's no doubt in my mind that she truthfully testified that she had a sexual assault, had been assaulted sexually in her past. I have to say, I also listened very carefully to Judge Kavanaugh as he testified, and I felt that the testimony he gave was also honest. He gave, I thought, very strong testimony that he was not there. And so I think that this committee has to face the difficult task of what burden of proof does it apply, what standard does it apply in exercising the advice and consent that it gives. And that's a very difficult thing that each one of us individually needs to face and deal with. As I've said, I don't feel that the evidence shows that Judge Kavanaugh was there that night. I believed his testimony. I believed Dr. Ford's testimony about the sexual assault. And because of that, I will vote yes today to move the nomination forward to the floor.